Welcome to the December 11, 2014 meeting of the City County Planning Board. At this time, would you please stand and join us in the Pledge of Allegiance?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Today's meeting is being broadcast live by TV 13. It will be rebroadcast at 10 a.m. Friday morning and again at 4 p.m. Sunday afternoon. Our first order of business today will be the consent agenda. These are items for which the petitioner has requested withdrawal or continuance, or items for which staff has recommended approval and no one has signed up in opposition. For public hearings today, each side will have a total of 12 minutes. There is no rebuttal period. Once the planning board goes into work session, no one will be allowed to speak unless a planning board member asks a question. Items under Section B of the agenda will require final action by the appropriate elected body, either city, county, or county commissioners. As such, votes taken here today are recommendations to go to them for their consideration. If you're addressing the board today, before you begin your comments, please give us your name, address, and zip code for the record. First order of business would be the approval of the minutes of the November 13 and November 24 meetings. Any board members have any additions or corrections?
Move for approval.
Second.
Motion, Mr. Mulligan, second, Mr. Younger. In discussion? All in favor? Any opposed? That's unanimous. Thank you. Now call on Aaron King to present our consent agenda.
Good afternoon, Mr. Chairman, members of the board. We've got a couple items for consent. The first one is item C1. It's minor subdivision exception 2013-2. We received some questions from some neighbors in this area this week, and we need a little bit more time to get those questions answered for those neighbors. I think also there's an attempt to have some more communication between the petitioner and some neighbors in this area. We did speak to the petitioner yesterday, and they will request a 1-month continuance to the January meeting. Staff would recommend approval of that continuance.
Okay. Move that we do the same thing.
Okay.
Second.
Motion by Mr. Lamb, second, Mr. Mulligan. All in favor? Any opposed? That's unanimous. Thank you.
Okay, the next item is D1. This is Planning Board Review 2014-9, and this is a request for Rehabilitation Facility C and Highway Business Zoning. You can see on the location map there the site in yellow. It's on the west side of Patterson Avenue, just north of 52. Again, Highway Business Zoning, existing building. It's about 2 acres in size. And this is the site plan that was submitted with the request. Essentially, it's an as-built survey of what's out there, and it does include the required common recreation area behind the building. Staff has reviewed this. It does meet minimum UDO requirements, and we would recommend approval of this. And just as another note, as you see on the agenda, we'll be talking about a text amendment for Rehabilitation Facility C here in a few minutes. Your action on this is completely independent of what happens on that text amendment.
Okay.
Move approval. Second.
Motion, Mr. Lamb, second, Mr. Mulligan. Any discussion? All in favor? Any opposed? That's unanimous. Thank you.
Okay, we'll move into the first hearing item, UDO 253, and this is a request by planning staff to amend the subdivision regulations of the UDO to revise plating requirements for private infrastructure. Before I get into this, just a little bit of background. I know that typically when we bring things to the planning board, what you're seeing at that point is a preliminary subdivision plan or a preliminary plan for apartments or multifamily. And after, we don't bring a lot of plating items to the planning board. So just to kind of give a little bit of a reference, basically after the planning board or elected body approves one of those preliminary plans, you've got your developer who goes back to the drawing board and starts working on their construction plans, submitting them through the various city and county agencies for their review and approval. Then once they get that, they can go out and start working on the site to put in the infrastructure, the water and sewer and streets that are needed for the development. What they can't do is put in the buildings until they get a plat reviewed and approved through our office. And in order for us to sign off on that plat, there are certain things that have to be done. There's very minimal levels of infrastructure that have to be put in, a stone base for fire and EMS vehicles to get into the site if they need to, street signs at least to show EMS responders where the site is and where the new streets are. And there's another thing that has to be done is if there's any incomplete infrastructure, they have to provide surety to the city that that infrastructure is going to ensure that infrastructure will be completed. We hold that surety, like I said, to ensure that's completed. And the UDO requires surety be posted for all public and private infrastructure. It's pretty commonplace in communities across North Carolina to provide surety for public infrastructure that will be dedicated to the city or whoever to maintain that. I think where our UDO deviates a little bit is that we currently require that for private infrastructure. And that's really essentially what this text amendment is geared towards. Again, the surety is posted before a plat can be signed and before buildings can be built, and we hold that surety either in the form of letter of credit, cash bond, or however the developer chooses to address that. We hold that until the project is completed. And the reason this has come up is staff has received several concerns or issues from some of the multifamily developers over the past several years regarding that requirement to post surety for that private infrastructure. Some of those issues are, number one, it's an added financial burden for the developers. You're having to go to an institution and get that letter of credit. Let's say you got $200,000 worth of incomplete infrastructure. You've got to get that letter of credit or that cash bond or however you want to satisfy it in that amount. The city also requires a contingency of 50% on top of that. So now you're looking at $300,000 tied up or allocated in that. After you get that to us and we okay it, we sign the plat, you go start building, well then you've got to turn around and pay somebody the $200,000 to put the infrastructure in. So it's kind of a double issue there. And really the main point on this is that second one, staff feels that we already have adequate safeguards in place to ensure that this private infrastructure is completed, either through the issuance of certificates of occupancy or stop work orders, basically through our permitting arm and inspections. If we go out to a site, an apartment site, and developers requesting a CO on an apartment building and the road hasn't been completed and half the units don't have water and sewer to them and it's not been completed, we can hold those COs until that infrastructure is done. We've got enough leverage to make sure that that private infrastructure is completed without having to have private surety for that private infrastructure on hand. So staff feels like we already have adequate tools at our disposal to make sure that gets done. And that last point, we only propose to modify these requirements for non-residential and multifamily. We would still require those for single family and for townhouse development because it is developed in a different style. It's sold off on a lot-by-lot basis. And really, we haven't heard any complaints or issues from those folks. I think they generally accept that. So staff does recommend approval of this text amendment to remove that requirement for posting surety for private infrastructure and non-residential and multifamily developments. And just as the last note on this one, this is an amendment to the subdivision regulations, so the planning board is the approval authority for this text amendment.
Okay. Thank you, Aaron. This is a public hearing. No one has signed up. Is anyone here that's opposed to this recommendation? Now declare the public hearing closed. And
I move for approval.
Second.
motion by Mr. Mulligan, second Mr. Younger. Any discussion?
Yep.
Yeah.
Okay.
Go ahead.
I just had a few questions. What exactly constitutes the private infrastructure? You talked about roads, and sewer and water, right?
Correct. And I'll give you an example for like an apartment development. A lot of those are, the drives leading in and then the parking areas that go with the apartment development itself. And if they have utility lines that are not going to be dedicated and accepted by city county utilities, then it would include that as well.
Okay.
Again, it's basically the infrastructure that we as the city are not going to be taking over to maintain.
Okay. And have you ever had a case where you had to call in a bond on one of these properties because they didn't complete the infrastructure?
Not that I know of, no.
Not for multifamily or commercial.
Okay.
For single-family residential, whether it be public or private, yes, the city has had to call some of those bonds in before. But again, if the type of situation we're looking at here, it's where a developer has gone in, they already have a lot of money tied up in the project because they are the one actually building the multifamily buildings, building the commercial project. So we have the ultimate leverage with them of the CO as compared to any other mechanism, whereas with single family, as Aaron explained, those things are sold off lot by lot, developed lot by lot, sold to builders, whether it be a tract builder, a local builder, or whatever. And so the need for the surety is there. But as far as I'm aware, for multifamily or commercial, we've never had to call in one of these bonds for private infrastructure.
And it's routine before you issue the CO that you go and make sure that all the infrastructure is put in? Is that part of the...
As you know, it could be done by phases, but yes, as part of the building inspection process, the water and sewer and the kind of things needed to serve those units are checked on a building by building basis. The zoning inspector goes out to conduct the zoning inspection for, you know, they're going to be looking at making sure that the parking lots, the drive aisles, the trees, the things necessary to serve that section of that multifamily development is in place prior to the issuance of CO.
Okay, and I just have one other question, and it's about, in the ordinance, it looked like you changed from 25% to 50% the contingency, and that's a change?
It's already in place. It's just our UDO was outdated. The city's infrastructure development guidelines had already changed that. It was just, we just needed to update the UDO.
Okay.
Yeah. Comment, question? Nope. Okay. Any other comments? All in favor? Any opposed? That's unanimous. Thank you.
Good afternoon, Planning Board members. The next item on your agenda is UDO 254. The petitioner on this item is the General Government Committee of the Winston-Salem City Council, and this request would amend transmission tower regulations in residential districts. As you all remember, City Council adopted an overhaul of the transmission tower standards about a year ago, and after that happened, they adopted another text amendment this September, UDO 250, which revised some issues dealing with tree save around cell towers. During the discussions on that text amendment, UDO 250, Council identified some other issues they had with residential tower standards, which they wished to revise. Those issues were, first and foremost, reducing the maximum height of residential towers from 199 feet to 150 feet. This is something that Council came up with when they reviewed the first 4 towers under that new ordinance that was approved about a year ago. All of those towers were 150 feet in height. That seemed like that was a more appropriate limit for them than the 199 feet that was originally in the ordinance. They also wanted to place greater limits on when monopine towers and monopole towers are allowed in residential areas, and they wanted to make unipoles or slick sticks the preferred tower type in all situations. And this is a slide here just to refresh your memory what all these terms mean. Unipoles, what Council wants as the preferred type, are basically flagless flagpoles. Monopines are towers that are designed to look like faux pine trees, and monopoles are basically a flagpole with an antenna array on top of it. So those are the 3 types of towers this amendment deals with in residential districts. So just a little bit more detail. Only unipole or monopine towers would be allowed where in tree stands where the majority of trees are evergreen. And the reasoning behind this is if you have a tower that's supposed to look like a tree and it always has its leaves, and then you get into a situation where you have deciduous trees where the leaves fall off in the wintertime, you're going to have this one basically fake tree sticking out like a sore thumb. So that's why Council wanted to limit those monopines that always have the fake leaves to only being in evergreen trees that don't lose their leaves. Unipoles would still be the preferred tower type in this situation, and the monopines would only be allowed where the petitioner demonstrated that that type of tower would be compatible with the area. The second type of tower that we were talking about, the monopole, would only be allowed in tree stands where the majority of trees are deciduous, where they lose their leaves. And this was designed to give an option to someone who didn't want to do the unipole, which is a preferred tower type, but give them something besides a monopine that they could do in these deciduous tree stands. So again, the unipole is the preferred option here, but monopoles would be allowed where petitioners can demonstrate compatibility with the surrounding area.
Kurt, go back a minute, please. That first statement, it says only unipole or monopine are allowed for 50% or more evergreen. Or do you mean that unipole and monopine are allowed only where 50% or more are evergreen? I mean, are you saying you cannot put a monopole?
Yes, it's saying you can't put a monopole where it's majority evergreen trees. You can only put a unipole or a monopine where it's majority evergreen.
Yeah, but I'm not sure. Okay, I'm not sure I understand.
And who would determine?
in that, yeah.
I'm sorry.
Go ahead.
Who would determine the ratio in those situations?
The petitioner would have to delineate on a site plan the makeup of the tree stand. Now, this wouldn't require the use of an arborist or a certified forester or anything like that, but since these are all special use permits, you all remember these residential towers, they would be subject to the special use permit council at city council. So if the council felt like the petitioner wasn't providing enough information on the tree makeup, they could always ask for more information. But again, with any special use permit process, the onus is on the petitioner to demonstrate why what they're asking is appropriate. So we tried to leave the ordinance language flexible and not too onerous for petitioners to have to go through.
Do they
But
serve?
go ahead.
Two questions. Same topic. Is a survey required? Do they have to locate the trees in the?
No, they
radius?
don't. They just
need a
have to.
technical statement from.
Exactly. Like they could
Okay.
just do the little scallop thing that sometimes you see on site plans that show the boundary of the tree stand,
Okay.
and just state on the site plan this tree stand is majority.
All right. Okay. Then the second bullet on that slide, where petitioners demonstrate monopines will be compatible with the area. How do they do that? How do they demonstrate that monopines will be compatible? Because it sounds like we're setting it up to where all we're going to have are slick sticks. Sounds like. Then I'm going to have another question. How many slick sticks does it take to replace the same coverage that a monopole gives you? Do you have to have 10 slick sticks versus 1 or 2 versus 1? I mean, I
Well,
think that's-
in response to your first question,
Okay.
it is the council's intent that the unipole is the preferred option.
Right.
So it is set up to encourage that as the default, and basically there's a higher standard if you want to do one of those other two types of towers. The way they would demonstrate compatibility is through their photo simulations. That's what I would recommend. There's nothing that explicitly says that's the method, but that's what petitioners have done so far in demonstrating which types of tower they want to use, is when they make those photo simulations. They can say, I'm doing a monopine, I'm in an area with evergreen trees, this won't stand out like a sore thumb. Now, sorry, what was the third question?
It was how
Amount of
many slick sticks does it take to replace one monopole? And maybe it's 1-to-1.
It's not 1-to-1.
Yeah.
You definitely have to do, I wouldn't say it's a 1-to-2 ratio, but you lose a good bit of capacity in the pole itself, because everything has to fit inside the metal structure of the slick stick, whereas with a monopine or even a monopole, you can add antennas and things of that nature. But it's definitely a loss. You're going to have more towers if you want unipoles, and that's something that was discussed with the council at the committee meeting. But
And you think it's approximately 2-to-1? Is that what
no, I wouldn't say it's that far, but I'd say maybe you get a.
But you know it's not 10-to-1 or 5-to-1.
It's
less than 2-to-1.
between 1-to-1 and
Okay.
2-to-1.
Okay. Thank you.
All right, Kurt, let me think. Help me understand the logic, though. If monopoles are allowed where it's 50% deciduous, they're going to be more visible than they would. Why would it not be allowed where it's 50% evergreen? I mean,
The reason that this was done like this is council wanted to give someone an option of another tower where you have deciduous trees. They said, we don't want to see these monopines and deciduous trees because
I understand that part. I understand not allowing the monopine where the deciduous trees are, but why would you not allow the monopole where the evergreens are? I mean, They're no, maybe they're probably less obtrusive than some of those monopines. I mean, but
I think, and I don't want to put words in the council's mouth here, but I think their vision was that even if a monopine is taller than the trees around it, at least it's a tree, it's an evergreen, or it looks like an evergreen. If you put the monopole there, that's always going to stand out as being different because it's just a steel structure.
okay, I'm sure. I guess there's some logic. I just don't understand it. That's my problem, I guess. Go ahead.
Okay. So I was almost done with the presentation. Just a little bit of summarization. Staff believes that the proposed standards would reduce the visual impact of transmission towers on these residential areas, but still allow for new telecommunications infrastructure in neighborhoods. And I'll be glad to answer any other questions.
Oh, I'm sorry. Go
I had
ahead.
a question. Is it the staff, when they come in and say that we're proposing monopine, would you look at the number of trees involved and determine that that's enough, that meets some threshold to be a stand? How would that work?
Well, ultimately, these are all special use permits decided by the city council. So they would ultimately have to decide whether that is or not. We could issue our opinion as to whether it constitutes a thick enough stand of trees as opposed to just 2 or 3 that are sitting out there that someone's calling a stand. But it would be something. It would have to be something that would more approximate the natural wooded environment. Would have to, for all appearances, be that way.
And would the trees have to be in that fall zone area, the ones that count as part of the stand, or could they be outside of it?
Well, it's not the fall zone. It's the distance, tower height circumscribed in a radius, so it's basically that area. So if they're outside of that area, it doesn't count.
Okay, that was my question.
Well, and if I could just kind of jump in a little bit on that question and related to an earlier question, similar to the way that we handle our tree preservation review under any development project, what we do is take a look at what was submitted, and if we find discrepancies or if we don't think it meets the requirements of the ordinance, then we would go out to the site, take a closer look to ensure that what we're looking at on the computer or whatever other research we've done is in fact what we think it is. And at that point, we would advise them, this would not qualify. But there's no definitive measurement. It's just a subjective, we don't think this would qualify as a stand, whether it be for the towers or whether it be for just the general tree save requirements for a development project in some other scenario.
Paul, like Mr. Lamb, we're not experts on transmission towers, so it's like the height going from 199 to 150. Simply because the first 3 came in at 150, does that mean that that's all it's ever going to be? There was a reason that 199 was requested initially, and I'm not sure what the difference is at 150 versus 199 as far as coverage, and I'm not sure, given our topo and theirs, there might be certain areas where 199 might be needed. Have we talked to the transmission tower folks? Are they okay with this one?
I did share this text amendment with the folks who dealt with the process previously. They said obviously they would prefer it the way it was under the compromise position that was done in UDO 244. Mm-hmm. That being said, they said that they could live with these rules, so there wasn't anything that caused them enough heartburn to come at the meeting and oppose it.
If the unique situation came up where they needed 199 because it's in a hole or somewhere, I mean, is there a process where they could ask for an exception?
The only
Rezone.
Right, that's what I was going to say, is just a rezone would still be available
To rezone
to a non-residential district.
Yeah, this is only the rules that it applies to residential zoning districts. And correct me if I'm wrong, Kirk, but the 199 is significant because when a tower gets taller than that, it's got to have special lighting.
Exactly,
on
it has to have FAA standards for strobe lighting. And with regards to where the 199 feet came from, that was just a number that came out of a compromise meeting that some neighborhood advocates and tower advocates had with council in last December, when after this came from the planning board, there was some discussion before the council version where it bifurcated from the version that the planning board recommended that the county adopted. That county version actually had heights in residential ranging from 150 to 180 feet. So this actually puts it a little more back in track with what was done in that ordinance, but the 199 feet was something to throw a bone, if you will, to the tower advocates for some other things that were taken away during that meeting.
So now we're taking it back. Okay. This is a public hearing, so there might be some other questions later. No one signed up as a proponent. Anyone like to speak in support of this? I see none. The opposition, Mr. Bryan?
Good afternoon, Planning Board. George Bryan at 1326 Glade Street, 27101. I'm the appointed representative of the Winston-Salem Neighborhood Alliance to come in and talk about what the neighborhoods discussed in relationship to this. And of course, you've heard of a lot of background on this. And in our initial discussions with American Towers on this, there was a lot of assurance that unipoles and poles and transmission towers that would be concealed in church towers and in monopines would be used in communities and would help to be compatible with the surrounding neighborhoods. As we've seen from the first ones that have been presented, that isn't necessarily the case. They've tended toward the monopole rather than the unipole. Did I say unipole? Monopole rather than unipole initially. So they haven't used unipoles. They haven't used the monopine as much as we had hoped as neighborhoods that they would look at. So we were pleased with the directions that general government has gone in this direction and what planning staff has looked at. I think the way it's worded, it does give that preference so that it helps neighbors when they're looking at it. In general, when we have talked to the various neighborhoods that we've been in contact with, they seem to prefer that unipole better. It seems to be less obtrusive. So really, the areas with this that seem to be less precise are the very ones that Mr. Hicks and Mr. Lamb have brought up already. What is it that we defined a stand of trees as, and how do you define compatibility? And I would certainly like to challenge the planning board in terms of the stand of tree. These towers can be located off center of the 4 acres, as we know. They don't have to be in the center of that. So sometimes they're located a lot closer to neighborhoods. Of course, they've got to be farther away than the fall zone that's in that. So isn't there some way to look at the circumference of that fall zone and what percentage of tree coverage or tree screening is provided there so that can be more precise, and when this goes to City Council, it can be more polished in terms of recommendations and in terms of negotiations with the neighborhoods. We would certainly like to propose that at least 85% of that circumference be screened by some kind of trees. Now, you've got 2 different types of trees there, the evergreens or the deciduous, and we're still concerned that if a tower is located too far off center, it's going to need that screening around the base, and I'm not sure whether that screening around the base has to be there if it's in the middle of the 4 acres of trees.
The base screening would be there regardless. Right?
Regardless? Okay. Well, that may alleviate a lot of that for the neighborhoods that are right close, but they have been very concerned about that part. The other is the compatibility. How do we define compatibility when it reaches the City Council on this? I would certainly hope, and I would encourage you all to put some language in there that would say that it would have to be agreeable with the neighborhoods. That would be one thing I would think that would be a criteria of compatibility, because there's a clear path here. If a monopole is recommended, and the neighbors say, this is going to be way too obtrusive, then they've got the unipole method to fall back on. So you've got a plan in there. If we could put some more precise language in there that would help, again, refine this before it gets to City Council, these will move a lot quicker, and the neighbors will have a way of being able to negotiate this and understand this and be protected in their home values and in their future values and living in their neighborhoods. So those were the only two things. Again, I found it a good way to look at it in terms of putting preference. Thank you.
Okay. Thank you, sir. Anyone else like to speak? Seeing none, I'll declare the public hearing closed.
I think it's fine, except my opinion is that it's fine, but except I hate to put a very discretionary requirement that doesn't have some objective standard, probably from the opposite perspective of the gentleman that spoke, but I'd like to, that's the only criticism I've really got of it, is that second bullet, and I can't remember what the exact wording is, but do you mind? Thank you. Because it's not a bullet. Yep, it's the second one, the second hyphen. Unipoles are preferred in such stands. Monopines are only allowed where petitioners demonstrate monopines will be compatible with the area. And I think we've got the same complaint, but the concern is probably different.
How are you going to determine that, Chris?
I'm not city council.
Yeah.
Well, that's one of my, I don't know, there's a different solution, but we're using very vague terms to describe even things like 50% or greater of trees. When there are standards in terms of canopy, or you're talking about the tree bases, so there is more specific language available when you're talking about communities. And we don't reference any of that. We're assuming somewhere down the line somebody's going to come up with something to make this based on, but we're not defining it at all now. We're not putting any criteria even of what you're going to reference when you're determining these.
Well, and I just wanted to interject relating to the second part of the second bullet there, the language that says that monopines are only allowed where petitioners demonstrate monopines will be compatible with the area. The actual ordinance language was something that the city attorney's office worked on with us. We originally had some different language there, but they wanted something that they felt put the onus on the petitioner through the special use permit process that does have very specific things that they have to demonstrate compatibility with legacy. They have to demonstrate that it won't injure property values or have any adverse health, safety, welfare, et cetera, impacts those 4 findings. So that's how, just to give you some background information on how that language came to be what it is.
This is city attorney language then?
Correct.
Yeah, well, they just shifted the burden, like you just said, where it makes it almost impossible to get, well, I think it makes it very difficult. But anyway,
I think just to reiterate, the purpose is to make it more difficult to do the monopines and the monopoles from council's perspective.
Yeah, and if you only need twice as many unipoles or slick sticks, whatever, as you do monopoles, I guess that's not, if you need 200 towers instead of 100, that's not that big of a deal in the scheme of things, I guess. The original petition came to us from the Tower Consortium, right?
Correct.
And I guess the purpose was to try and come up with some streamlined, clear guidelines whereby they could put something that would be agreeable with the community in a relatively quick fashion. Isn't that what the
Well, the real purpose was to open it up for towers in residential areas.
That was
which
their
were previously not allowed.
Right. That was their first and foremost concern, is they couldn't put towers at all in these residential areas, and they wanted just the ability to get in there under some, and they proposed that language at first, and then we as a staff, worked with them to kind of massage that a little bit, and then, of course, it went through the public process before it finally got adopted there.
And they did originally want something more streamlined for what they saw as less intense towers. Ultimately, they got on board with the compromise position that council crafted because it still gave them a lot more rights than they had previously.
In the residential area.
Right.
Thank you very much.
Yeah, I just want to say that I see this as a welcome change because there were some issues with the way the ordinance, when it was actually implemented with the first cases. I think that the understanding that was part of that compromise meeting that Kirk was talking about, those assumptions didn't come to pass in reality. And I think this corrects that to a great extent. And what I mean by that is there was an assumption that the monopole tower would only be used in very narrowly defined circumscribed cases, and that we weren't ruling it out, but we were allowing it in certain narrow situations. But because the tower companies had that option of monopoles, that was their preferred option. And so they could go for that every time. This is just a way to limit it to some extent, which was the original intent, which was to prefer the unipole. And that is what is in the county version in residential. So it's bringing us in line with what's in the county.
Well, I got a question. Back to what Mr. Bryan said about the neighborhood, if someone has a problem with this, in other words, my understanding is that once, if this passes today or whatever, then it's going to go straight to council. Every application or whatever is going to go straight to council.
It already does.
Okay, it already does.
With what was passed earlier.
Okay, all right. So I would gather that if a homeowner or someone in this area has a problem with it, they would be going to council to
Correct.
present their case, right?
This is a special use permit process, which means there's a public hearing and sworn testimony, factual evidence, all of those things. Now, someone couldn't just lobby their council member in advance of the hearing because they'd have to follow the correct special use permit procedures, but everything would be heard like basically a courtroom type system with council acting as a panel of judges, basically weighing the evidence that property owners or residents in the area could also interject.
Yeah.
And I'll just add to it that the difference now with the more recent amendment is that the planning board would not be having a public hearing. You'd just be seeing the site plan. And it would simply be not whether you like it or not, it would simply be, does this comply with the ordinance before it gets sent on for public hearing at the city council?
Do we then have to determine if it's compatible? Is that one of our things?
Now, that compatibility would be the council's decision on that.
I mean, we don't have to determine if the site plan is compatible?
The compatibility issue is one of the findings of fact that the city council would have to make on a special use permit. So, I mean,
Not part of the site plan review.
you might could interject your opinion that you don't think it's compatible, but you don't have to make a finding that it is.
How is it not tied to the site plan? Because like the tree save, or if it's 50% or greater of the trees, is that not part of the site plan?
Well, again, I mean, that would be part of the review, but whether or not putting the monopole versus the monopine or the slick stick in under those two scenarios, that's not something that we would say whether or not the trees were 50% evergreen. We would say whether or not it met the required stand of trees, but we wouldn't be making a recommendation or determination on compatibility.
Okay,
Planning
good.
board
I'm going
would-
to stop before you change your mind then, because I don't want to get into that compatibility here.
And if you look at the actual ordinance language, it's in a section that clearly says this is the elected body's decision.
We'll never have another public hearing on the tower.
We won't.
Right,
Right.
right. I move approval.
Second. Motion, Mr. Lamb. Second, Mr. Younger. Any further discussion? All in favor? Any opposed? That's
Not that they get
unanimous.
tired of it.
Thank you.
next item on your agenda is UDO 255. The petitioner is Friendly People That Care, Group Home and Provider Services, and this request would allow the use of Habilitation Facility C in the General Office Zoning District. Just to provide a little background, Habilitation C facilities are facilities that provide habilitation, rehabilitation services, or recreational activities for 13 or more handicapped persons. These facilities are licensed by the state of North Carolina, and they don't provide any room and board. Currently, the Habilitation C facilities are allowed in multifamily zoning with Board of Adjustment reviews, certain more intense business districts with planning board review, and a few other districts with just a staff review. The petitioner wishes to allow this use in the general office district with staff review. In looking at this request, staff believes that Habilitation Facility C is an appropriate use in the general office district with just staff review. These facilities are often found in office-type buildings. That's where, in fact, I'm not aware of any that aren't in those type of buildings. And no residential accommodations are provided on site. Also, the UDO classifies both Habilitation Facility C and office as low-intensity uses, but the current permitting processes are different. The impact of a Habilitation C facility on a surrounding property should be no greater than a comparable office use, such as a medical office. And in fact, I've got some pictures that will show this is actually a much less intense use than you might think of a medical office with lots of people going in and out. That would just be a staff zoning approval process. So this is some pictures the petitioner provided that show what the inside of their facility looks like. Again, this is just to provide therapeutic services for folks who have Alzheimer's or similar types of disabilities. You can see this used to be an office building. It's got the cubicle walls in there and the drop ceiling. So from a use standpoint, this doesn't look any different than you'd expect of another office use. There's also not a lot of people coming and going through these facilities throughout the day, like a dentist office or something like that, so it shouldn't be any more impactful than your standard office. So in addition to allowing Habilitation C in general office, the staff also believes that additional changes to how and where habilitation facilities are permitted should be made at this time. Staff recommends changing the planning board site plan review that's required for the pedestrian business, highway business, general business, and central business districts also to that staff zoning review. Again, the same as office districts currently. The impacts of Habilitation C on adjoining properties is no greater than other uses allowed in these districts with staff review. And removing the PBR requirement will help streamline the process for developing these facilities and providing for handicapped folks in the community. Additionally, the corporate park office, limited business, and institutional public should also be added to the group of zoning districts that allow Habilitation C. So again, we didn't see any reason as a staff why you have to limit Habilitation C to such a small group of districts when it's a fairly innocuous use. Staff also recommends allowing Habilitation A and B facilities in more zoning districts. These uses are the same as Habilitation C if you read their definitions in the UDO. The only difference is they serve fewer people. Habilitation B is 8 or fewer people, or I'm sorry, Facility A is 8 or fewer people, and Habilitation B is 9 to 12 people. But for some reason, the UDO currently only allows the more intense Habilitation C in business districts. So, for example, if I'm an operator of Habilitation C and then I lose clients and I'm down to 8 people, I theoretically would have to be shut down under the way the current code is structured because that would make me Habilitation A. So that didn't make sense to the staff. We're proposing that all 3 of these would be allowed with just a staff zoning review like other office uses. Overall, these ordinance changes will make it easier to provide care for handicapped persons by expanding the range of appropriate zoning districts that habilitation facilities may be located in and simplifying their review process and eliminating unnecessary rezonings. Glad to answer any questions.
Any questions of staff?
Yeah, I have a few.
Sure.
By handicapped, do you have a definition?
Chris, is there a definition of handicapped?
I can read it to you. A person with a physical or mental impairment which substantially limits one or more of such person's life activities, a record of having such impairment, or being regarded as having such an impairment. This definition does not include current illegal use or addiction to a controlled substance. This definition includes Willie M. children, but does not include persons who are dangerous to others. Dangerous to others means that with the recent past, the person has inflicted or attempted to inflict or threatened to inflict serious bodily harm on another, or the person has acted in such a manner as to create a substantial risk of serious bodily harm to another, and that there is a reasonable probability that such conduct will be repeated. So all that wording was to mean what it does not include. It does not include anyone who is considered dangerous to others.
And it does not include rehabilitation for substance abuse type situations. Right. It's basically just standard physical types of handicaps or mental handicaps.
And the definition of C, that's 13 or more, so there's no cap on the number. Is that
correct?
Okay.
Is it cap by square footage somehow, though?
Not through our ordinance. I'm sure that by state statute, and perhaps the petitioner could answer to this, I mean, just like child daycare centers, I mean, I'm sure there are square footage thresholds per folks enrolled in the program through the state licensure procedure, but there is no threshold in our ordinance.
And there is a licensing requirement.
I'm sure there's some cap somehow, but I don't know how that's...
And the petitioner is here to answer any of the more technical questions relating to the impacts of their operation or licensing type issues.
And I did misspeak. There is a requirement of you have to have at least 100 square feet of heated space provided for each person enrolled. And then there is a minimum of 100 square feet for each person enrolled with a 4,000 square foot minimum of outdoor area associated with it. So there are requirements, and I believe that's consistent with state licensure, but I'll let the petitioner speak.
Well, this text amendment seems to make a lot of sense, not only for Facility C, but A and B as well, so I'm glad you included that. What am I missing? What potential downside of this exists?
Staff couldn't really think of any. That's why we supported the text amendment. We believe, again, that if you look at these uses, they have an outdoor recreation area. That's really the only difference from a office land use. But in terms of people coming and going, there's certainly not the rush and demand to use a facility like this, as even with an insurance agent, or certainly not a bank or a doctor's office, things that are allowed with just a zoning permit from inspections and a wide range of uses.
And just one point of clarification, when we talk about an outdoor play area, it's not necessarily an area that's developed. It's a green space where folks could go sit. It's not anything that has to be developed as a playground or anything such as that. So, I mean, I don't want folks to get that idea in their head. It's essentially, a lot of times these office places would probably have them anyway. So just, it's not really anything out of the ordinary.
You want to have the public hearing, or somebody got other questions of staff right now? Maybe a little later, okay. First person signed up, Spencer Bennett.
My name is Spencer Bennett, 1065 Inglewood Drive, 27106. I am in favor of this text amendment. Just wanted to, you did a good job. You said everything I was going to say. But you know, of course, it's 13 or more handicapped persons receiving habilitation, rehabilitation, or recreational activities. Geozoning already permits recreational services. They already permit an adult daycare and vocational training facilities. That's already permitted with geozoning. Some of the other zonings for geo is fraternity or sorority, funeral homes, hospital, and hospice care. So this is not an extraordinarily tough text amendment, at least in my opinion. It's just really just adding to what should already be there, since HB already allows it in some of the other office areas. But just wanted to kind of point that out. But most of what was going to be said, he already covered. So that's all I have to say about that.
Thanks, sir.
Thanks.
Angela Curry.
My name is Angela Curry, address 6215 Glenway Drive, Winston-Salem, 27107. And I'm the owner of Friendly People That Care.
Okay.
So,
Anything you'd like to say?
No, we just want to expand our business, and we're growing. We're pretty much we're full where we're at, and we're just growing because there's a major need for this type of facility. Yeah.
Thank you. Mr. Curry.
Larry Curry, address 6215 Glenway Drive, 27107. I guess I just want to say I'm in support for this text amendment.
Okay.
Thank you.
Thank you, sir. Anyone else like to speak in support of this? If not, then we'll turn to the opposition. Mr. Bryan, you're up again.
Planning Board, George Bryan at 1326 Glade Street, 27101. We had, again, a good showing at the Winston-Salem Neighborhood Alliance in talking about some of these issues. This was one of them. You've clarified one, which was the definition of handicap. Let me say, personally, in relationship to this, having been a person that's run group homes and leased group homes, I'm very favorable toward the population and the services that are needed there. The intent of this particular text amendment of moving toward the GO is fine, great. It didn't make any sense. It makes sense now. There was a chart, however, that was attached to this. I don't believe it was pulled up, Kurt, in the midst of this, where you also changed how the decision-making was done in certain other zoning areas. And there were two of those zoning areas that had neighbors somewhat concerned, because we always look at what the zoning is immediately connected to our residences and neighborhoods and just want some input on it, not that it would be ruled out, but just some input on it when the business tends to change in those areas. And one of those would be in pedestrian business, which tends to be very close to residential. The other in institutional, because the institutions are generally located in the midst of residential neighborhoods, and just having some input or some feedback in that process as it happens. And if I understand that chart, I think you were trying to change the pattern on those two, and those were the two areas. So I just encourage you to leave those as they were, rather than to change them and just still have that as some review for those two zonings out of those.
To which ones are you referring?
The pedestrian business, and I believe it was
IP, institutional.
IB, yeah, institutional.
IB and IP. Okay. Thank you. Kirk, you want to speak to that?
Again, the way this was done before, it was a P, which is basically just a planning board review. That's effectively a site plan check off. It's making sure that the recreational area is there, making sure all the other ordinance requirements are met. Again, we didn't feel as a staff that those were enough of a reason to subject a petitioner to the extra time needed of the planning board review. You know, they have to get on the cycle, they have to go before the board. We felt like that was something that could be done with the existing ordinance language, with just the staff zoning officer review and inspections where you go get your permit. But that was the staff's opinion, is that there wasn't enough potential impact from these uses to necessitate the current planning board review.
So it was not a public hearing anyway, Mr. Bryan. I mean, the public wouldn't have a chance to come in. We would just make sure it's complied with the ordinance, and now we're letting them do our work for us. It's kind of what... Okay. It's still a public hearing. Anyone else like to speak in opposition to this? If not, then I'll declare the public hearing closed and...
Move approval.
Second. Motion, Mr. Lamb, second, Mr. Mulligan. Any discussion, comments?
Yeah, I guess I had some of the same concerns that were just mentioned about the not just the IP and the PB, but LB was another one. It seems that, and it's really more for habilitation C because of the number of clients that potentially could be impacting close to residential areas. I just think it's good to have just another layer of review, a P rather than a Z in habilitation C. I don't have a problem for the A and the B, but I just, because of the numbers that we're talking about, that could be a concern. And again, I don't have a problem with the petitioner's request, which is the general office district. I think that's perfectly compatible. But I just think, when you're talking about something that could have a major impact, that it's good to have another layer of review.
But all we would review would be site plan, right?
Right. Again, the staff's premise in expanding the petitioner's request to these other districts, including LB, is that there is something like the office district that's allowed in LB with just an inspections permit right now, that generally you could have a much larger office building than you're going to have one of these rehabilitation or handicap type facilities. So that's already allowed without any extra oversight from the planning board in terms of a site plan review. So we were really just trying to have more standardization in terms of the process we put someone through. If you own an office building and you have one type of what we see as generally an office using tenant versus another, we're just trying to provide more standardization.
What will happen if this passes? The landlord or the tenant will come to the zoning officer and say, I need a zoning permit for habilitation C in this GO property. Is that what will happen?
Exactly.
Pay their $100, $200 fee. They don't have to get on anybody's calendar or anything.
Exactly. Right. The goal is just to streamline it to provide the handicap services the community needs.
Okay.
With a site plan. You still have to do a site plan.
You still have to do a site plan. But that's only to prove the outside green space and stuff like that. But they could do that. They could do that if there's a survey in their chain of title somewhere. If they can find that and map out an area, that would be acceptable. Okay. The demand is truly great, and I just think we need to allow this use. And this comes from a person that has 3 habilitation C tenants in 2 different office parks, and now that it's going to be so much easier for these tenants to go find spaces somewhere else, I'm probably going to lose all these folks as tenants, but I'm still in favor of doing it. We really do need to streamline the process. It's very burdensome and cumbersome for folks like the Currys to, real professionally managed operation to, expand, get into the business and do things like that. And I think anything we can do to help them out is something we need to do.
I'll second that.
These are already allowed in multifamily districts, right?
They're already allowed in multifamily districts, I believe, with an elected body special use permit.
Board of Adjustment.
Board of Adjustment.
Yeah. So, we're talking about worrying about them in PB. We're already allowed in multifamily. Right. So, anyway, that's just my comment. Any other comments, discussion? We have a motion for approval. All in favor? Any opposed? One, Ms. Duncan opposed. Okay. Thank you.
Mr. Chairman, members of the board, we now have a item of a sale or disbursement of parkland. It's actually, this parkland is not being sold or dispersed. There's going to be a lease tendered on the property. This is Winston Lake Park, and its property is located at off the east side of 311. The proposed use is the first tee would be coming in and building a structure to expand their presence there and having a structure that Mr. Grant will expand upon when he gets up here. But basically, the requirement for sailor disbursement of parkland is required to have planning board review so that anytime parkland is being potentially sold off, we can find out if that's really what we want to do and allow a public input for that type of thing. Again, because it's a 10-year or greater lease, this is leases for 10 years. Tim included it as something that would come before y'all. And if they construct this structure there, have a 10-year lease, after 10 years, they may keep it there and expand the lease, which we did recently in another park for the model railroaders about a year ago. Planning staff thinks this is a fine example, and we're in support of it. And just to get a slightly better idea, this map just has the whole park in green, but actually where we're showing this building would go is at the south end of a parking lot that's next to the clubhouse. And we have a couple pictures that were taken out on the site. A little dark here, but the existing clubhouse for the golf course is on the left here, and this building would go at the end of the parking lot over here, which this is sort of shot directly at that area. So it would just be a new building located there. And I have a graphic, I believe, of the building. And this is the proposed building they intend to put on the leased property. So it'd be a small lease for the placement of that building for that use. So staff is supportive of this, and I'd be happy to try and answer any questions you have.
Thank you. This is a public hearing. No one has signed up. Mr. Grant, would you like to say something? Yeah.
I have a question.
Anyone opposed to the recommendation? Seeing none, I'll declare the public hearing closed. Have a question, Mr. Hicks.
For accessibility to the facility, Mr. Grant, you may be able to answer this question. Is there anything in the plans for expansion of the parking lot that is in front of the facility to give more access to the new building?
Great question, which leads me into the bond package that was just approved this past November. We have in addition to working with the First Tee, we'll have another project that will be taking place at Winston-Salem Golf Course, which will allow us to relocate or move back the driving range, move it back onto that hill. So when you would visit the First Tee building and come out on the back side on the deck, you would actually be lined up with the driving range. Back behind the driving range now on that hill, we will also have an expanded and brand new outdoor special events center, picnic shelter, where we can move the tournament play over to the picnic shelter after tournaments are concluded, as well as host not only the First Tee in that facility, but also the Ernest Moores. In addition to that, that parking lot will expand, and we'll have access from the lower end of Winston Lake Park by the lake to get up to the golf course as well, too. Even though it will be a gated entrance, we will still have an entrance that will provide an access which we used to have before the public road was closed.
Yes. Excellent. Very exciting news.
Yeah. Very nice. Thanks, sir. Okay.
Move approval.
Second.
Motion, Mr. Lamb, second. Mr. Younger? Yes.
Actually, I had a couple of questions for
I'm
you
sorry.
that I can get to ask.
Okay.
Wanted to know a few details about the operation. Like, for example, is this going to be fees charged to participants, or is it free of charge? Do you know?
Well, let me relay those questions to Mike Barber. He's here in attendance. Mike is the executive director of the First Tee. We've had a relationship with the First Tee, in fact, since 2007, I believe, and Winston Lake was the flagship or the very first location that the First Tee decided to partner with. So I'll let Mike address your question.
Mike Barber. We utilize P.O. Box 236, Clemens, North Carolina. Great question. To give you an overview of the program, and I'll try to be very brief, we will program at Winston Lake in 2015 in the spring, fall, and winter. And the cost of a spring session, which is 9 weeks long, one afternoon a week, for our kids is $75. But a poorly kept secret is we don't turn anyone away. We have over 1,000 kids, and over 500 of our kids are on scholarship. So the parents and kids register online, and if they do need a scholarship, they'll answer 4 or 5 questions and then receive the benefit of our programming.
Okay, and I understood from the letter that you have educational programming as well as athletic.
Yes, we're a life skills organization, age 7 to 17, and we teach core values and healthy habits, and we use golf as a vehicle to reach these young people. And one added value that we're really excited about for this learning center is we're going to add programming that includes pre-ACT prep, pre-SAT education. PwC has agreed to continue financial literacy classes for kids in the community. So the offerings, we're going to go beyond what we typically do, classes and clinics, and we provide our programming to the Ernest Morris Camp during the summer. We're going to go beyond that, and we're going to reach not just the kids that are traditionally in our First Tee classes, but the community as well.
Okay, and another question I had was, is it possible to sell once you build the building? Could you sell it to another party, or?
I know there's counsel that gives you advice. I'm an attorney by trade too. No, this, the leasehold interest is a real estate interest, and I know that would be prohibited. This would be for the purposes of First Tee programming only.
Okay.
And I'll just mention that First Tee is not only a program that operates in Winston-Salem, and you can see what a big and substantial program it is in Winston-Salem, but it is also has an excellent reputation throughout the country. Mm-hmm. And you don't have to turn on the Golf Channel too much to kind of hear the virtues of the First Tee program extolled quite a bit. So.
Forgive me, but if I may make one quick comment that I never get a chance to say publicly. Working with the staff has been a great experience, and we really enjoy our partnership with both the city of Winston-Salem and Forsyth County at other locations. So thank all of you.
Thank you, sir. I don't know which one of the pages say that, but anyway, I forgot. Got it, okay. Any other comments? We have a motion for approval, I believe. Any further discussion? All in favor? Any opposed? That's unanimous. Thank you. Okay. I guess we're to committee reports.
There are no committees to report from.
Okay. Take care of that. How about staff report?
Staff report, I keep it. Oh, no. Did Walter leave? Oh, I'm sorry. I was going to introduce Walter Farabee, our new project planner, to you since I saw him out there. So we'll have to catch him next month for you. And then also, as far as new caseload, we only have 4 cases to come to you next month. 2 or 3 of them are planning board reviews?
2 final development plans, 1 rezoning, 1 general use rezoning, and 1 rezoning in Walkertown.
So we won't have you terribly busy at the first meeting next month, but we will try to load it up for your work session in January to get you started right. So that's it.
That it?
And yes. Yeah. Other than Merry Christmas and Happy New Year to everybody on the board. We thank you very much for all that you've done throughout the year, all the hard work that you put in reading, studying, listening, and giving the elected bodies the benefit of your wisdom. So thank you.
And I want to thank you, and please convey to all the staff how much we appreciate everything that you guys do to make us look like we know what we're doing.
That's right.
Appreciate it. So happy holidays to you and your staff as well. So, any other comments? Anyone? Yes, ma'am.
Over the past few months, I've found myself in a situation where work is taking more and more of my time. To that effect, I sent a message to the mayor yesterday, and this will be my last meeting. I am stepping down from the board. I've enjoyed working for you, but I don't have the time to give it that this position requires anymore. So I've enjoyed working with you, but this is it.
Well, it's not yet. You'll have to come back. We want to thank you publicly, so you'll have to come back at least once more. But anyway, we appreciate the service you have provided to the board, and hate to see you go. Thank you. Okay. Anything else, anyone?
Just want to wish everyone a Merry Christmas and see you next year. Motion to adjourn.
We're adjourned. All right.